One second, my net. Yeah, can you hear me now?
Yes, we can hear you.
Right, excellent. Okay. What we thought the last session, if you remember, we had the last two sessions actually. We had a discussion on the entire question of the right to life, and we looked at the different dimensions of Article 21, and of course we looked at the question of what happens when there is no right to life, which is the emergency time, and the relationship of the right to life to the question of emergency. That's the kind of a context which we addressed in the last session. But I felt that there's one leftover point which I thought is very important, which is there in our course outline, etc., which we really had to touch upon, which is the question of the right to privacy. And the right to privacy as part of both the right to life as well as part of the other fundamental rights. And we'll touch a little bit on why privacy is such a significant or such an important right. And before we get on to the second part of what we want to look at in this class, which is the entire directive principles of state policy. When we think of the right to privacy itself, there is a certain kind of a common sense understanding of what you mean by privacy, right? And we all have that common sense understanding. And the common sense understanding is really premised on very simple fact that you have a room, you have a house, and what happens in my room or my house is my business. It's not the state's business, not anybody else's business, etc. Right? And there is a certain important dimension to that because you think about it, the right to privacy. I mean, among the initial cases, uh, was around the entire question of police surveillance. The police were conducting what were called domiciliary visits. Late at night, they'll come to your house, knock at your door, come into your house with on the supposed question of investigation. And the Supreme Court at that moment in time held that these kinds of domiciliary visits violate your right to privacy. There is a certain problem here. I don't know if the tension which I've figured out, which is uh, if you say, I mean, Supreme Court again held that a man's home is his castle. So you can't enter the castle without informing the man. Of course, you get the problem immediately there, right? That is the right to privacy and the certain kind of a patriarchal nature of the right to privacy. If a man's home is his castle, then what does it mean as far as women's rights are concerned? What does it mean as far as the question of domestic violence is concerned? What does it mean vis-a-vis the question of unequal rights within the home sphere is concerned? What does it mean in terms of the rights of women within that private sphere, where the man may assert all kinds of rights against the people who are subordinated to him? That's a dynamic or a dimension to keep in mind when we talk about the right to privacy. So Supreme Court, I mean, again, we go back to the Indian Constitution. We look at it, right? There is no right to privacy. There's no specific mention of the right to privacy. Look at the South African Constitution, by contrast, it specifically mentions the right to privacy. So there's a way in which privacy then gets, it's not there in the text, as it were, but as we have discussed in all this time period, when we think of the Constitution, we think of the Constitution as the text, we think of the Constitution as judicial interpretation, and you think of the Constitution in terms of its constitutionalism or constitutional history or constitutional imagination. So it's definitely there in terms of constitutional history and imagination, and it's most definitely there in terms of judicial interpretation. Right from I think the 60s onwards, the Supreme Court has been reading in Karak Singh's judgment, the minority judgment read the right to privacy as a part of the right to life. After that, there's been a range of judgments in which right to privacy has been seen as an integral part of the right to life, and it's come in many important contexts, right? For example, assuming that you're subjected to uh, what is called the entire question of the state gives you truth serums to tell the truth during investigation, right? So in their terminology, to make you tell what they think would be the truth. And does that violate the right to privacy? The court holds that it does violate the right to privacy because this privacy also includes the right to bodily integrity, right? And this case comes up again, particularly in the other context, right? And here the 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 government of India takes a very strange or a very unique position. There's been a number of cases where the Supreme Court has held that there's something called that there's some we've created something or there's something called the right to privacy. The Union of India takes the position in the initial state in the other case, saying actually there's no such thing as a right to privacy. It's only a stat at best. There's no such thing as right to privacy relying on two judgments. They say that privacy doesn't exist as far as the judicial interpretation is concerned. At which point, the Supreme Court says, let's clarify the position. Is there a right to privacy? Is there not a right to privacy? And so they constituted a nine-judge bench to look into the question of is there a right to privacy as far as the Indian Constitution is concerned. And the nine-judge bench comes to again overwhelming conclusion. All nine judges agree that there is a right to privacy, both under Article 21 as well as other fundamental rights. So you just see the framing, right? If you think of the right to privacy as both under 21, which is the right to life, as well as other fundamental rights, obviously it's seen as something very integral or very essential to the fundamental rights chapter itself. And nine judges of the Supreme Court are saying that it is so integral. So the question you ask yourself is why? Why is privacy so integral, right? And there's a huge debate on the entire question of privacy. People have argued with some justification that privacy is a bourgeois right. End of the day, I can say I have a right to privacy because of a house. If you don't have a house, you don't have a room. What right to privacy are you talking about? People argue the right to privacy is a patriarchal right. So the end of the day, it's man's control over woman within the sphere of the home. So what is this great right to privacy the Supreme Court is defending or is advocating as an integral part of the fundamental rights uh, chapter, right? And we've circulated the reading to you. As these judgments are, they're long judgments, but we try to put out certain paragraphs, certain pages where you can read, which put out what the ratio of the judgment is, right? I'll take you to a little bit of that, maybe a couple of paragraphs. We don't have time to read, of course, more than a couple of paragraphs, and to try and get a sense or understand, right? Why? Why is the Supreme Court seeing the right to privacy as being embedded not just in one fundamental right, 21, but in a range of other fundamental rights as well? Why did nine judges of the Supreme Court think of this such an important right? Think of it this way, right? We can think of privacy as a secondary right. You can say, end of the day, right? The right to privacy, the right to be what you want within the privacy of your home. Okay, fine. I mean, end of the day, what does it do? Is it protecting your right to behave as bizarrely as you want in the privacy of your home? If so, what's the big deal? Behave bizarrely at home. You may behave bizarrely at home. Is that the right you want to protect? Or is there something more about the right to privacy itself? Right? And let's just read a little bit of the Puttaswamy judgment. Again, okay, maybe make one last point on this. Uh, yeah, is the I mentioned before that nine judges of the Supreme Court come to the conclusion there's something called the right to privacy. That's the Puttaswamy judgment. Again, if you look at the judicial, if you look at judgments, right? Keshavananda Bharati, which we looked at, was 13 judges. Puttaswamy is 9 judges. So they're very important judgments. And the reason why I'm taking through a little bit of this judgment is also because I think that this is a judgment, if you internalize its language or internalize its logic, it is something which you can use in your advocacy. And hopefully the point will become clear at the end of this as to how Puttaswamy can be used as far as your advocacy is concerned on a range of fundamental rights, really. So you can see that in this sense, I kind of concur with the Supreme Court that it's a very, very important judgment. Suresh and Sala might have a slightly different opinion also, but I think that's part of the debate and discussion uh, which we need to have. But let me first share with you the Kutuswami judgment. Okay. Yeah. Sorry. The point I want to make is the judgment is 9 judges. There's a plurality judgment, which is 4 judges come up with one opinion. That is Justice Chandrachud Kehar and Nazir and one more. I forget the fourth judge. And the other judgments, all individual judgments, right? And so there are 4 plus 5 judgments as far as the Puttaswamy, the judgment itself is concerned. You refer to the 4 judges signing on to one opinion is plurality opinion, and the others all concurring opinions. But let's just get a sense of what this is the Chandrachud opinion on what does privacy mean. Yeah. So somebody can just please read paragraph 168.
I'll read.
Please, please.
What then does privacy postulate? Privacy postulates a reservation of a private space for the individual, described as the right to be let alone. The concept is founded on the autonomy of the individual. The ability of an individual to make choices lies at the core of the human personality. The notion of privacy enables the individual to assert and control the human element, which is inseparable from the personality of the individual. The inviolate nature of the human personality is manifested in the ability to make decisions on matters intimate to human life. The autonomy of the individual is associated over matters which can be kept private. These are concerns over which there is a legitimate expectation of privacy. The body and the mind are inseparable elements of the human personality. The integrity of the body and the sanctity of the mind can exist on the foundation that each individual possesses an inalienable ability and right to preserve a private space in which the human personality can develop. Without the ability to make choices, the inviolability of the personality would be in doubt. Recognizing a zone of privacy is but an acknowledgement that each individual must be entitled to chart and pursue the course of development of personality. Hence, privacy is a postulate of human dignity itself. Thoughts and behavioral patterns which are intimate to an individual are entitled to a zone of privacy where one is free of social expectation. In that zone of privacy, an individual is not judged by others. Privacy enables each individual to take crucial decisions which find expression in the human personality. It enables individuals to preserve their beliefs, thoughts, expressions, ideas, ideologies, preferences, and choices against societal demands of homogeneity. Privacy is an intrinsic recognition of heterogeneity, of the right of the individual to be different, and to stand against the tide of conformity in creating a zone of solitude. Privacy protects the individual from the searching glare of publicity in matters which are personal to his or her life. Privacy attaches to the person and not to the place where it is associated. Privacy constitutes the foundation of all liberty because it is in privacy that the individual can decide how liberty is best exercised. Individual dignity and privacy are inextricably linked in a pattern woven out of a thread of diversity into the fabric of a plural culture.
Yeah, personally don't think this is one of the best written paragraphs, but because there's a range of ideas, right? And you don't get that sense of clarity. What is the idea which the quote is actually focusing on this? But the broad point you can make about this paragraph, I think it's still a very, very important paragraph, is that you're making a connection or a link between the idea of, for example, when you think of the privacy as the idea of the right to be let alone, right? The right to be let alone is the question of autonomy, right? When you're let alone, there's a way in which you can be an autonomous personality. And what does it mean to be autonomous, right? What does it mean to be autonomous is the ability of the individual to make choices, right? So choice making is about your question of autonomy. And what are the choices you're thinking of in the context of privacy? The choices which are again very, very well put, I think, to assert and control the human element inseparable from the personality of the individual, right? So the idea that you make decisions which are absolutely central and very key to who you are, right? That's about the right to privacy. So here you get, again, very interestingly, privacy is not a zonal notion, It's not about what you do in the privacy of your home, I mean, it can be about what you do in the privacy of your home, but it's really about your ability to make decisions about your personal or your intimate life, right? And so that's the foundational kind of a shift which the court is articulating in this dimension. You're moving beyond the idea of the zone, or you're expanding, right? You're saying privacy postulates a reservation of a private space for the individual. Great, right? But from that, you're moving on to the notion of the autonomy. From autonomy, you're going on to the ability of the individual to make choices. And you're from that, you're going on to the question of the human element. And human element, of course, then goes on to the notion of of dignity, right? And the idea that that your right to make decisions about your personal intimate life is also about your notion of dignity. And yeah, the highlighted part, for example, recognizing a zone of privacy is but an acknowledgement that each individual must be entitled to chart and pursue the course of development of personality. Hence, privacy is a postulate to human dignity itself, right? So the idea that there's a way your right to make decisions about your personal or intimate life without anybody else telling you what those decisions should be is really fundamentally integral to dignity itself. So you see how the court is making all these linkages. You move from the idea of the right to be let alone to your right to make to question autonomy, to the right to make decisions about various dimensions of your life, to the right to dignity. So you see a range of kind of rights which are which form a constellation around this question of the right to be let alone. And again, see what are these decisions you make about your personal or private life. The court is telling you that it could include thoughts and behavior patterns which are intimate to an individual, right? Which are intimate to an individual are entitled to a zone of privacy by one's few social expectations. Again, very, very powerful, very, very interesting thoughts, right? Where the court is actually making the point that end of the day, right? The question of privacy is also about a freedom from social expectations. How do you find that zone where you can be who you are without society telling you what you should be, right? And what society telling you what you should be links up, of course, fundamentally both to the question of gender and to the question of sexual orientation, gender identity, right? Where the idea that the behavior patterns which are absolutely intimate to an individual and which can find expression sometimes against what society is telling you, right? And that's what the court is saying needs to be protected. It's that freedom to be who you are, regardless of what society expects you to be. Again, it's a very important notion because again, the Indian Constitution is about saying that it's not just about the question of about the about freedom from the authoritarianism of the state. It's also about freedom from the authoritarianism of society, and it's a very important idea which the court is articulating in this context. And the last part of it, which is also very important, in that zone of privacy, the individual is not judged by others. Again, I think, very powerfully put. What is the zone of privacy? Uh, it's not zonal. It's not the idea of just of the bedroom, the way it's often thought, but it's about a space where you're not judged by others. And if you're not judged by others, what happens? Privacy enables each individual to take crucial decisions which find expression in the human personality. We get back to the idea of the human personality and how privacy is about enabling the growth of the human personality. It enables individuals to perceive their beliefs, thoughts, expressions, ideas, ideologies, preferences, and choices against societal demands of homogeneity. Again, we get back to the idea that society has a certain kind of demand of homogeneity, and really the idea of how do you preserve your beliefs, your thoughts, your expressions, your ideas, ideologies, preferences against the societal demands. And the last point, which is very critical again, is this privacy is an intrinsic recognition of heterogeneity, of the right of the individual to be different and to stand against the tide of conformity in creating a zone of solitude. Right. So privacy also in the way the court is phrasing it links up to your notion of a plural society, links up to the notion of a heterogeneous society. If there's a pressure for homogeneity, pressure to be one like the other, right? Then the role of the state in this case is how do you ensure that the individual who stands against his community, against his group, is also allowed recognition for who he or she is, right? And so that's the understanding which the court puts forward as far as privacy is concerned. Uh, it's a important idea. I don't know if it's fully clear, but maybe a couple of examples. I'll give you a couple of examples which will make that a little clearer. Uh, in the US context, the right of a woman to a woman's right to abortion is seen as a part of the right to privacy, right? How is it part of the right to privacy? If you ask the question within the notion of zonal notion, it makes no sense. Surely you're not saying that women have the right to privacy as long as they're within the homes, and they don't have the right to privacy the moment they go outside the home. It's obviously linked to the idea that privacy is about your right to make decisions about your personal and intimate life, including your decision whether to have a child or not to have a child. That's so personal, so intimate a decision. It's a part of your right to privacy. Again, think back to the what we read, right? Privacy is about the question of the choices which you make, which are really about the development of the human personality. Your decision to have a child or not to have a child can actually be fundamental to your growth of your personality. Yeah, Gitakshi, yeah.
Arvind, I'm just thinking about the recent UCC that Uttarakhand has implemented, and one of the provisions is that couples who live in a live-in relationship have to report it on some portal and all. And basis what I read and what we are reading, I think then that amounts to violating the privacy of individuals.
Absolutely,
Right?
absolutely.
Hmm.
Because the Uttarakhand regulation, what you're saying is again, it's a decision crucial to defining who you are. Right? You might want to be in a relationship with person A and
Yeah.
person B, and surely state has no reason to monitor, to control those particular decisions. And this is precisely, I'm glad you're thinking this way because the point is this, right? Tomorrow, if you do a representation, right? If you do a representation on this question of the Uttarakhand UCC provisions, then I think you have no choice but to reference Buddhism.
Right.
Pull out a couple of these paragraphs, right, which make this point crystal clear. Pull out one more paragraph, which is even clearer on this, which goes straight to that, actually.
Yeah, it speaks about intersection with gender and marriage and all
Yeah.
of that pretty clearly. Yeah.
It's very clear. One more paragraph, which is even clearer in my head, which actually is crystallized in one paragraph. Yeah. This is just read this paragraph F, please.
Yeah, go ahead.
Please.
Privacy includes at its core the preservation of personal intimacies, the sanctity of family life, marriage, procreation, the home, and sexual orientation. Privacy also connotes a right to be left alone. Privacy safeguards individual autonomy and recognizes the ability of the individual to control vital aspects of his or her life. Personal choices governing a way of life are intrinsic to privacy. Privacy protects heterogeneity and recognizes the plurality and diversity of our culture. While the legitimate expectation of privacy may vary from the intimate zone to the private zone and from the private to the public arenas, it is important to underscore that privacy is not lost or surrendered merely because the individual is in a public place. Privacy attaches to the person since it is an essential facet of the dignity of the human being.
Yeah. So the simple point I'm making, why I quoted, why I asked you to read this, is assuming you're doing a representation to the Uttarakhand on the Uttarakhand bill, what you say that the Supreme Court in Puttaswamy has recognized that privacy includes at its core the preservation of personal intimacies, sanctity of family life, marriage, procreation, home and sexual orientation, connotes the right to be let alone, connotes individual autonomy and recognizes the ability to control vital aspects of his or her life. And it's precisely this dimension of privacy which is hit at a very fundamental level with the Uttarakhand proposed UCC. So I think that's just to get again the simple point we're making is the citation or the quotation is very important. Right? You can't just say you shouldn't just be saying that Puttaswamy recognizes. Puttaswamy recognizes in one of the paragraphs from Puttaswamy, which you can cite, which makes your case, right? And so that demands a little more work. Obviously, you have to have a sense of the judgment and you have to be able to pull out what part of the judgment will be useful as far as the advocacy effort is concerned, right? So yeah. Then okay. I think the point has been, obviously, I think the point has been, you guys have got the point, but maybe maybe give two other references to think through this particular point on the centrality or the vitality or the importance of the notion of privacy. If
Arvind, can you also complete it by looking at the triple test? Because that gives you the limitations, because it's not an absolute right. Again, they have curtailed it.
Yeah.
Maybe that gives the people a much more realistic picture of the right that is available currently.
Yeah. Triple test, we'll have to find it on the.
Yeah, you can just tell it maybe.
Yeah. Let me find. Sala, you go ahead. I'll give you 2 minutes. I'll find it.
Yeah, see, just like you have seen that all fundamental rights that we have seen for so far are all subject to certain limitations. So even the right to privacy, while the Supreme Court has very eloquently elaborated on the right to privacy, they finally say, however, there can be state action which can actually, it will permit state action to invade into your privacy in certain circumstances. First, like, there should be a law which will permit it. Like in the Uttarakhand example, which was mentioned just now. So there is an action which should be authorized by law. So the UCC in Uttarakhand authorizes that action. But all of us definitely feel that the law itself is bad. But supposing an action were to be taken under that law, how would you challenge it? So the law also talks about, Puttaswamy's judgment, Supreme Court also says that the state action should also have a legitimate aim, which could also be for the legislation itself. What is the objective? The objective that it seeks to achieve should be legitimate. It cannot be some bizarre objective or, or something which is not constitutionally acceptable. And thirdly, that the state action should also be proportional. So it cannot be, for instance, in UP, they had put up on the hoardings. I don't know why my video is not on. Yeah, okay. I thought it was on. Yeah, they put up the hoardings of all the people who were supposed to have vandalized.
Yeah, now you're visible. Please go ahead.
Yeah, vandalized the properties. And that was challenged. And the Supreme Court struck it down, saying that it was disproportionate, even assuming that these people indulged in some kind of vandalism. It doesn't mean that the state can put up their photos and authorize and publicize all of them, because it is disproportionate to the act that they're supposed to have done. So this is the triple test that in Puttaswamy the court lays down, the circumstances under which state action can actually break into your privacy. So I think, so this will give you, it's not an absolute right like anything else. So unless you have this clarity, sometimes in your application, you may not be able to look at it critically. So these three should come into your should come to the top of your mind whenever you're using the privacy argument.
So Shankar has a question. I was about to ask if the state can claim exceptions like decency or morality to curtail the right.
See, again, this is a good question. And the decency, morality point, of course, is there in 19, right? Just to keep that in mind. If you say privacy is under 21, 21 doesn't have the restriction on decency or morality. That's not there, right? It has to be, as Silas is indicating, 21 says, no person is deprived of life or personal liberty except a procedure established by law, right? So the only limitation on 21 is your right can be restricted as long as there's a procedure established by law. So the question you're asking is, what is that procedure established by law? Again, the court has gone into the question, of course, that procedure established by law is not just any law, right? There has to be a law which is a reasonable. That's one kind of a requirement. There must be a law. The triple test again. There must be a law must have a necessity to, you must be able to demonstrate necessity why you put that law in place. And thirdly, you have to indicate, you have to be able to demonstrate that it's a proportionate response to the requirement, right? To the requirement that you have. It's not disproportionate. I'll give you an example of proportionate, disproportionate, which maybe make that example a little, sometimes it can make it quite clear, is during the 370, right? When 370 was abrogated, and they they shut down internet across the state of the Union in India, shut down the internet across the state of Jammu and Kashmir, right? And the argument which was made by Kapil Sibal is that this is a disproportionate measure. His argument again was assuming, right? You say Facebook is a place to which national security is threatened. Therefore, I'm curtailing your right to access Facebook. That could possibly be a proportionate response. But if you cut down the internet for the entire state of Jammu and Kashmir, it's a disproportionate measure. Right? So you get the argument how proportionate, disproportionate works. So you show there's a law, you show it's necessary, and you show it's a proportionate response to the problem being put forward. So the Uttarakhand example again is you take the limitations in this dimension as well. You to make the if again see you're not, I'm not asking you to make a legal argument in court. Right? That's not the point I was making. My point is different. It's more a rhetorical or a more a public kind of a point, right? You're making the point where the rhetoric of the expressive part of the judgment of the constitution is very important. You might not necessarily need to look at it as a lawyer, because you're not framing the argument in court. But what you're doing is you're appealing to the court of public opinion. Right? And the court of public opinion is very important. I mean, people feel very passionately and very strongly that the right to privacy is something which they hold very dear. Right? And you have to tap into that feeling and say that it's outrageous. The fact that they come up with a law which violate really a core dimension of what it is to be human, what it is to be human. Right? And that's the argument you phrase within the that's a public dimension as it were. So the triple test is great, but I think for lawyers, I don't think we need to worry about the triple test in a larger uh, in the context of a public statement or what shall we say public uh, pamphlet or something of those lines. Where again the point I'm making is you put a little bit of a legal dimension to your argument and draw upon the idea of what does the right to life mean, right? And there, you leave it to lawyers to argue the matter of whether the right to life or the right to privacy is overwhelmed by the concept of the restriction, right? And that's a argument which can go either ways. I take that point well, which Saila made. But the point here is to appreciate the importance of what that right is, and that has to be appreciated. Okay, I don't think lawyers also appreciate the relevance of the importance of what privacy means, not as a zonal notion, but as a notion integral to dignity and selfhood, right? And so I just want to complete that part of it, which is the if you I made the point on the question of the shall we say the question of the right to abortion, right? In the Indian context, where privacy and personal has come together most powerfully, is in the context of the decriminalization of same-sex relationships, which is the Nafej judgment, right? Where again what the court did, what the court held, is that the right to privacy includes the right to make decisions about your personal life, right? Which includes the right to decision who to love or who not to love. So the idea, right, that why is the state again? Look at 377 of the then Indian Penal Code. It criminalized what we call carnal intercourse against the order of nature with any man, woman, or animal, right? So what the state in effect was saying is if a man and a man or a woman, okay, man and a man in particular, has an intimate relationship, right? That stands prohibited by the law. So the argument then, using the framework of Puttaswamy, is it's really a fundamental violation of your right to privacy, which is your right to form intimate relationships with the person of your choice, right? And so that's that's the dynamic which one needs to understand in a larger public sense. And the court, of course, understood or they really got this argument that 21 is really about the right to how privacy and dignity come together, right? And so that appreciating that link is really critical in terms of the the logic of Puddaswamy and how it's been most importantly applied, right, in Navtej and applied, of course, in a range of other judgments as well. But this is the important critical dimension to really appreciate with respect to the to what Puddaswamy can mean in terms of our larger in terms of larger forms of public pub, public argument. Uh, I think that's what I wanted to share on Puddaswamy. Maybe maybe we can just read one other quick paragraph by Justice Nariman and leave it at that. Again, this is important. I just share this one paragraph with you. Yeah, just what again? See here in the previous paragraph, it is a bit of a jumble in terms of range of ideas which are put together. But I think this Justice Nariman's judgment kind of crystallizes that a little bit, right? In terms of whatever we've discussed till now, into three dimensions of what privacy actually means. And just please read this one.
In the Indian context, a fundamental right to privacy would cover at least the following three aspects. Privacy that involves the person. That is, when there is some invasion by the state of a person's rights relatable to his physical body, such as the right to move freely. Informational privacy, which does not deal with a person's body but deals with a person's mind, and therefore recognizes that an individual may have control over the dissemination of material that is personal to him. Unauthorized use of such information may, therefore, lead to infringement of this right. And the privacy of choice, which protects an individual's autonomy over fundamental personal choices. For instance, we can ground physical privacy or privacy relating to the body in Articles 19(1)(d) and E, read with Article 21. Ground personal information privacy under Article 21 and the privacy of choice in Articles 19(1)(a) through C, 23, 21, and 25. The argument based on privacy, being a vague and nebulous concept, need not, therefore, detain us.
So you got a sense of, again, of the way you can think of privacy in terms of the body, in terms of the information, in terms of trust. There are three important dimensions which are highlighted by Justice Nariman in this part of the judgment. And I think we can end with the. There's lots more to say, of course, but we have more ground to cover. So we'll end the privacy discussion with maybe I'll just share two other anecdotes or two other references, and then we can move on to the next part. The privacy and creativity is also a very, very important connecting link, right? And I'll give you a reference on that. Is if you'll have read the early feminist classic, right, which is Virginia Woolf, A Room of One's Own, right? And what is the point? Her point is that if you ask the question, why are there so few women in science, why are there so few women in arts or literature, the answer she provides is because women don't have a room of their own, right? And again, she's the way the Justice Chandrachud's opinion went, right? You move from the idea of a space, a room of one's own, to the psychological dimension of what does a room of one's own mean. And the way she illustrates this is quite brilliant. She says that you think of the even great writers at the time, someone like Jane Austen, right? When she's writing, she didn't have a room of her own. She's writing in the living room, right? Her Pride and Prejudice or Mansfield Park, which are the great book that she's writing. And each time somebody rings the bell, you hide your manuscript because you don't want the person to see it. And then that indicates, right, the question of the lack of the right to how creativity and privacy are linked, right? So again, because the point, you go back to the judgment makes the point of the pressure for the pressure for homogeneity is exerted by society. So to find that space where you can be yourself is not always easy. And in that context, a room of one's own is very important. Again, the gender dynamic which Wolf identifies is this. What is the psychological space? I think all of you guys, especially I'm sure many of the women in this room will definitely empathize with this. She makes the point that if you're a meaningful woman is at home, you're always harassed or by some demands by tea from the husband or dinner from whoever else, blah, blah, blah. And her point is that, I mean, how do you be creative? You're stuck with all these stupid demands of tea and this thing from everybody around you in the family, right? So that's what you mean by room of one's own, where you have the psychological space to be yourself and allow your creativity to develop. So it's a very, I think, very important dimension which is pointing out too of how privacy links to creativity, links to autonomy, links to plural and heterogeneous society. A range of linkages which privacy has, which is why it's considered such an important part of the fundamental rights chapter. So I think again, I think personally think that judgment, though a lot of my friends have criticized, I've said that no, don't go overboard in the privacy judgment because yeah, Saila is very right. End of the day, the point Saila is making is what is the enforceability implementation of this right? That's a good, very good question. But my point is to go back to it again to say we have to understand the expressive language of the law and the concept. And I think that concept we haven't understood clearly enough. Because, see, again, I'll give you one more example. We had this, we were doing this, I think we were making this argument on the freedom of religion, right? We were challenging the freedom of religion law, right? I think in Uttar Pradesh and doing a draft on that or whatever. And I pulled out a paragraph from Putuswamy. And again, right, how does freedom of religion come in? You saw Justice Nariman's opinion, right? You're making the point. At the end of the day, what is as personal and intimate to you as a sexual orientation or gender identity is a religion you choose to follow or not to follow. And that's a choice which defines who you are. It's choice is integral to your sense of dignity. It's integral to the sense of to the human being that you are. And if there's a law which prohibits you from converting or changing your religion, then it's fundamentally a violation of right of privacy. Right? So again, you get a point, right? Every single human rights issue, we can think of how it links back to the notion of privacy. And here's what I'm asking for is a conceptual appreciation of the importance of privacy. What I'm hoping that you'll get is an appreciation of its importance, right? And how we can make an argument using this particular language of moving beyond the zonal to the relational and the autonomy dimensions and the freedom dimension of privacy. Yeah, with that I'm going to end. And Jonathan, I think you had made the point you wanted me to stop and give people a chance to come in if they'd like to come in. So I'll stop now.
Thanks, Arvind. Anybody, if you have questions, we can just take a couple of minutes and just have a freewheeling discussion before we move to the next part. Okay, in the meantime, I have a question. So does this only apply vis-a-vis the state? How about private bodies or society for that matter? Does it also extend to that?
See, the fundamental rights chapter, you go back to 12, right? Applies to the state. Your fundamental rights are vis-a-vis the state. But the exceptions, of course, are threefold. Three rights, right? You look at 17. 17 again is the prohibition of the practice of untouchability. That applies to society's concern. 15.2, which is discrimination with respect to access to water bodies, etc. There again, the citizen is involved, and the question of bonded labor, right? So it applies vis-a-vis the state. That's clearly there. But here the argument, of course, is what can the state then do to facilitate or to allow for the development of individuals' right to privacy? What is the state's obligation as far as that question is concerned? What is the state's obligation to protect individuals on grounds of their sexual orientation, regardless of what, in spite of what society may think? Right. So the states, you have a law by the state which should be repealed because of the fact that it reflects a certain kind of maybe a societal consensus, but goes against the rights of the individual.
Thanks, Arvind. I was mainly asking because of all that controversy around 70-hour, 90-hour work weeks. Say a private body imposes 70-hour work weeks on their employees. Could they refer to this judgment or the privacy to sort of push back against that? That was
No,
mainly.
so I didn't get what are we referring to?
No, the entire controversy of the 70 or 90-hour work week by the Infosys chairman and the L&T chairman. So if 70-hour work weeks seem imposed, which cut at France privacy, can they also reference this and sort of pushback?
Saila, you want to comment on this?
No, but why are you saying privacy?
Okay.
No, because of the angle about the autonomy, the psychological space to think. If I'm always made to work, I may not even have that space, even though I get paid for it handsomely. So
No,
could this argument be used against that as well?
I mean, I think you have better arguments, more solid arguments for it. It's right against exploitation, it's arbitrary, it's like, it's a lot of other things apart from privacy.
Sure. Okay.
I have a question, Arvind.
Yeah.
How do we look at this? Uniform Civil Code, is it not affecting the right to privacy to some extent? And how should we look at at the background of triple test?
See, the Uniform Civil Code again is many things, right? I mean, we picked up on one provision, which is the entire question of the notification you have to give with respect to unmarried couples living together. That is a clear linkage to the question of the right to privacy, right? And so the question we're asking is, can you challenge this on the basis that it violates the right to privacy? Yes, you can. Will you win the case if we challenge it? That I think is the question we don't have an answer to, right? Because the 21 and the limitations, of course, are there. So we can think of judges going in either direction. But I think the case is a strong one in terms of, if you look at the precedent, in terms of the way way Putaswamy has been applied in a range of contexts post that. The kind of protection which is there to couples, married couples and unmarried couples as far as the court is concerned, right? So there's a way in which you can make a case for sure that the UCC kind of a provision violates your right to privacy. But again, as Mr. Kanabran was very fond of saying, the state defines the law, the state defines the
No, the law defines the offense and the state defines the offender.
Yeah. So I can't predict what is going to happen when you file that petition, which is Sila's very, very important caution. So don't get too carried away with the rhetoric, because you may not get what you're talking about. So that's an important point. Sila, you want to comment on this as well?
No, Shakti, you're only referring to that one particular provision of UCC, or generally you're talking broadly about UCC?
Yeah, only about that particular provision.
Yeah.
Mainly about that particular provision.
Very clearly, I think it violates, because one, it will be to consenting adults. See, unless there is a minor involved and, other kinds of things. Clearly, it is to consentive adult. And look, using the triple test, what is the objective that they are trying to achieve by this? This is moral policing. And how do you come in the way of two consenting adults living together?
Mm-hmm.
And so I think, and it's disproportionate. So I think it should, actually answer all the tests in our favor.
Should we move on? Anything more? Any more thoughts, comments, suggestions? Yeah.
Go ahead.
I hesitate to ask this because it's really sort of fundamental, I guess. We're talking about rights, right to life, right to privacy and so on. But is any right actually something which we give each other, which is a mutual thing? In other words, is there such a thing as a fundamental right, or is it always something which we agree with each other that we will accord these rights to you and you will accord them to me? Is it always a mutual sort of, I don't know. Well, maybe I've made my question clear. I'm not sure. And maybe it's a stupid question. I'm not sure.
No such thing as a stupid question. Maybe I'll give you a stupid answer. That's what I don't know, but I'll try my answer, which is See, way we understand rights, again, from the human rights perspective, is you think of rights as really a product of struggle. Rights don't fall from the air. They're not the gift of the state. They're something you achieve through struggle. Even, for example, the what Marx says, right? He talks about the 7-hour working day. He says his words. He says in place of the pompous catalogue of the universal rights of man, you're the modest Magna Carta of the 7-hour working day. And he demonstrates how that right is achieved through people's struggle over a period of time. So each of these rights we are referring to is really a product of a struggle. If you're talking about the 377, the kind of a question, if you're referring to the right to abortion question, all of them are really a product of a struggle. So I put it within that frame. I say that let's look at rights more as a product of struggle, and understand is they're not necessarily as a gift, but something which is in process. It's a kind of a you get it once you fight for it.
No, I mean, just to add to what Arvind said, I mean, the question whether do we give it to each other, I think very much, because while yes, the state is central to it, whether it is giving dignity to each other, like in the women's question, is she given with dignity within the four corners of her house? So, and a woman would never experience the rights conferred under the Constitution, whether it is equality or liberty or all other rights or freedom of speech expression. Probably no woman in this world is ever really enjoying any of these rights to its full extent. And so also many of the oppressed and depressed communities. So probably a very privileged few are actually enjoying it in its entire essence. So yes, that's where I think in the preamble, the term fraternity, which Arvind pointed out, that unless there is fraternity, none of these rights can really be enjoyed by all of us. And fraternity is not something which the state can impose or the state can protect. It is something which we as the people should imbibe those values and live by those values. And that's the only true way that all of us can actually achieve and enjoy the rights given to us or recognized, confirmed by the Constitution. So I don't know if that...
Could we even say then, thinking of that fraternity that you've brought into it, that the law is only, if you like, the tip of the iceberg of what a full complement of rights. If we had a truly fraternal society, that the law's only kind of the tip of the iceberg of what we should be, of how we should be. Would that be?
In an ideal world, maybe yes, but in a non-ideal world, maybe no.
Yeah.
So you have to find ways in which the law helps you achieve fraternity. Like, for example, in the Indian context, you'd say something like the Special Marriage Act, with all its imperfections, is a move in that direction, where you're saying that actually you can marry across lines of religion and caste, and it's allowed by the law. Right? So there's a law which encourage or facilitate or allow for fraternity. Or, for example, if you have the fact that neighborhoods are segregated on the basis of religion, right? Different communities live in different parts, and some places you're prohibited from living if you happen to consume non-veg, which is a code for if you happen to not be Brahmin. So there's a way in which the law should come in at those points. So I think in imperfect society, which we live in, the law has a very important role to play to address the worst dimensions of the non-fraternal behavior. Again, the argument would be the entire question of the Article 17 of the Constitution is a similar kind of thing. So Article 17 is the prohibition of the practice of untouchability, which again the state comes in and says that we must prohibit the practice of untouchability. So that's the only way you'll achieve fraternity.
Thanks very much for that. Thank you.
Yeah, I think somebody else.
Go ahead, Vinay.
Yeah, I just wanted to add something that Mahavir Tyagi says in the Constituent Assembly debates. He puts it in very simple terms when he says that the state comes into being not because it has any right of its own. It is the people who deposit their rights and forego actually their own right, a part of their rights, deposits it with the state. And so therefore the state is organized and constituted not by depriving people of their rights, but by the voluntary will of the people to enhance those rights. So I think that idea that we are born with rights and we have decided to deposit it with the state, and the state has a role to enhance those rights and not just simply bestow something. I mean, even there's I've one thing that I've started practicing is to be conscious of the language whenever I use and talk about rights, is that nothing is bestowed upon us. In fact, the more we say, and at least in my school and my textbooks, we have been told we have been bestowed with rights. I think nobody bestowed any rights. We have all decided to uh, deposit our inalienable rights with the state. And so I think that is a big revelation for me. I mean, those words are very powerful. It's very simple, but I think it's not spoken enough. This concept.
That's the basis of what you call the contract theory, right? Which is the Hobbes law of Rousseau. All the argument of the state comes out of the individuals entering into agreements among themselves and agreeing to create the state, and as you rightly said, forego certain powers and give it to the state, right? And so that's and the state in turn will protect all of you. That's the understanding of the contract theory. But then this will be a controversial area, because there will be contract theory, there will be Marxist theory of the state, many different ways in which we can think of the state. So, but that's one viewpoint on how we think of the state. Yeah. Thanks.
Right. Yeah.
Sure. Should we now move on? And okay, let's move on then. We have 1 hour to look at the director principles to the best possible extent. Again, see, I think the way to look at this is these are, I mean, introductory at best, right? Introductory to various concepts, and we hope that you'll take it forward in your study later on, as it were. Right? Let's look at the directive principles of state policy. I'll just open it out for you 1 second. Yeah, can you see the directive principles?
Yeah, Arvind, we can.
Okay, just again, just so you know, I mean, I'm sure you know this by now, is let's go back. We look at the Constitution as a document as a whole, right? Part 3 and Part 4 are referred to as the soul of the conscience in Glanville Lawson's term. The conscience of the Constitution is Part 3 and Part 4, fundamental rights and directive principles. Till now, we've looked to some extent, right? Again, I hesitate to say we looked at, because there's so much. We looked at the fundamental rights chapter. We looked at the question of equality, especially the 14, 15, 16, 17 kind of a relationship. Freedom. We looked at in particular 19 and 21, in particular these two dimensions of the freedom debate. And we will look at the freedom of religion later. We haven't come to that as yet. And that's one part of it. But the gap, of course, you see over here is, of course, all of this are what you broadly call civil and political rights, right? And what is the distinction? Again, it's a very crude distinction, not always true. But when very crude distinction between civil and political and socio-economic rights is civil and political rights, right? If you look at, for example, the question of, say, freedom, right? Freedom of speech, expression, etc. Right to freedom of speech, right to freedom, assemble peacefully without arms, etc. What we want from the state on that is state not to interfere. Native rights. You don't want the state to do anything. That's all you want the state to do. But when it comes to certain other rights, right? If you look at, say, right to education, or the right to health, how do I guarantee as a state the right to health or the right to education without me making positive provision for the same, right? So the tension or the dilemma between directive principles and fundamental rights is directive principles has a component of again of rights which are not easily which are not which you can't just say negative. They're not just negative rights because the positive obligations which are cast upon the state, right? So it's a far more, in some ways, it's far more challenging for the state to actually provide ensure that these rights are protected, right? Yeah, these all, it's a very crude distinction because there'll be many people who disagree for very good reasons of the distinction between positive and negative. Because if you say the entire question of right to fair trial, right? Right to fair trial is hardly a negative right. The state has established courts. The courts have to be there before you can even guarantee that the person has a right to fair trial. Right. So it's a crude distinction, but at some level it can potentially work out. Right. The other point to make is that during the drafting of the constitution, of course, the discussion is that what are the rights which should be justiciable? Then what are the rights you can go to court to get enforced, to get implemented? And the consensus among the drafters of the constitution is the rights which can go to court to get implemented are what we today call the civil and political rights. As well as the socio-economic rights, which are one part of the directive principles, the consensus is that we can't as a country afford to ensure that they're justiciable. Right? What is justiciable? Look at this again. This is the directive principles. So 37, right, which says the provisions shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental of the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Right. So you get it very clear that they're not enforceable, but they're nevertheless considered fundamental in the governance of the of the country. Right. And what are these principles? Again, just have a glance at them. Right. Just have a glance at them. Is the 38 is broadly the state obligation to secure a social order for the promotion of welfare. 39, we look at more closely. 39 is to do with the entire question of concentration of wealth and inequality. That's 39A and B, or 39B and C. And 39A, capital A, equal justice of village panchayats, right to work, just and humane conditions of work, living wage. So you get the broad sense, right? Cooperative societies, UCC, early childhood care. Yeah. Okay. Okay. Broadly, I'm not going to go into the detail of each of these. How do you think of these principles? Again, it's very interesting. You go back to the Constituent Assembly debates. I just have to quote what T.T. Krishnamachari has to say on this. Vinay, since you're the Constitution expert, what is Constituent Assembly debates expert? What does T.T. Krishnamachari say on the directive principles?
For no, I'm
just pulling it like I'll read it out. He says, it's a beautiful quote actually. He says, he calls the directive principles a veritable dustbin of sentiment, sufficiently resilient as to permit any individual of this house to ride his hobby horse into it. Right? So that's one viewpoint, right? It's called what Professor Bakshi calls the dustbin theory or the directive principles. What are the directive principles? It's a dustbin, right? With everything which you can't implement is there. That's one way of thinking about it, right? So it's a veritable dustbin of sentiment, sufficiently resilient as to permit any individual of the house to ride his hobby horse into it. That's one way of thinking about it, right? But the other way of thinking about it is again it's a very good piece by Tarunab Khaitan, where he makes the argument that you think of the directive principles again as embodying certain expressive the expressive part of the Indian Constitution, right? There's a way in which something enters the Constitution, it embodies your way of thinking about certain issues. So it's very important that though D.T. Krishnamacharya calls it a veritable Dasmana sentiment, it's actually even the expression of the sentiments is important as a guiding light as to the way the framers thought about core or central issues, or what is central or fundamental, as 39 says, what is central or fundamental, or what is fundamental to the governance of this country, right? The directive principles are fundamental to the governance of this country. Therefore, we need to know them. And Tarunav's other point, of course, is if it is so useless, why do so many countries have the directive principles of state policy? Right? That's the question he's asking. So he answers it very well, actually. I don't know how many of you had a chance to read that piece. It's a very good piece, though it's not necessarily an easy piece to read. It's maybe go over it. You can't read the whole thing again, but I think the title is quite indicative, right? What he says, the DPSP is about the expressive accommodation of ideological dissenters, right? Who are the ideological dissenters? Of course, the Gandhians, the Hindu right, and the socialists. So the socialists, of course, think it's not, it's liberal, it's not, it doesn't have a socialist dimension to it. The Gandhians think that the village, why is not the village the central unit, as it were? And of course, the right thinks that, where is the place of Hindutva as far as the constitution is concerned, right? And again, Tarunav's point is you're drafting a constitution, right? End of the day, I mean, the important point to understand, the constitution is a compromise text, right? It's not, it can't be the opinion of any one thinker. Again, go back to the objectives resolution. Nehru's point again and again is to make the point that, this objective resolution is non-controversial. Everybody other than maybe very, very few people agree with the fundamental premises of this document. And therefore, please don't look at this as lawyers do, in a spirit of narrow legal reading, but look at the spirit underlying it, and let's go with this consensus that we the people give to ourselves this kind of a country which is based on, again, the language of sovereign, the language of republic, and the language of fundamental rights of speech, expression, thought, belief, etc. Right? That's broadly the frame which Nehru uses. So the point being, if everybody doesn't agree with you, what do you do, right? And T.T. Krishnamacharya actually is quite perceptive. He says, you put them in that dustbin. And you don't necessarily agree with the Hindu right, put them in the dustbin, right? You don't necessarily agree with the Gandhis, put them also in the dustbin, right? Socialists also, you don't fully agree with socialists, put them also in the dustbin. So put them in where it sounds nice, it's expressively beautiful, but end of the day, it may not mean much. That's his viewpoint. Tarunav's viewpoint, of course, is that it's two very important points he's making. You understand, right? The directive principles as really a way in which you're accommodating, not all the principles, but some core principles. So understanding it as a way you're accommodating your ideological dissenters. So is there a dissenting imagination in the Indian Constitution from the fundamental text? His argument, yes, it is. It is. It's there in terms of the core demands of the right. The right's demands was the UCC. UCC is there in the directive principles. The Gandhian demand is prohibition. Prohibition is there in the directive principles. Right? The socialist demand is to deal with the entire question of inequality. And the socialist demand is to deal with the question of inequality. And again, that is there as far as the directive principles are concerned, right? So let's look at each of these a little closely and see how is it accommodated, right? Again, it's a very interesting piece where Tarunav is able to make the case as to the forms in which each of these demands are actually accommodated in the text of the directive principle. Right? Again, let's start with maybe the question of prohibition, the question of cow slaughter, and see how is prohibition of cow slaughter, how are the demands of prohibition of cow slaughter accommodated within the text of the directive principles. Yeah, anybody can guess where, just looking at this, right? Where is prohibition? Where would prohibition have been accommodated in as far as the frame as far as the directive principles are concerned? Let's go then. I guess it definitely. I assume it can't be equal justice. It can't be organization of village panchayats. Prohibition cannot come under the right to work. Cannot come under, I assume, just in humane conditions of work, living wage. I don't think it can be participation of workers. It can't be promotion of cooperative societies. It's obviously not the UCC.
Public
Prohibition
health.
can't. Sorry. Okay, wonderful. Public health. Okay, let's read public health. Somebody please read it. Yeah, somebody please read it.
Duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties. And in particular, the state shall endeavor to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and of drugs which are injurious to health.
Yeah. So the Tarnab's point in this case is you're reading the entire question of prohibition as a subset of the larger question of raising the level of nutrition and the standard of living. By doing that, you're containing, right? What he calls the logic of containment. You're containing the broader ideological demand of prohibition within a narrower frame within a frame of levels of raising the levels of nutrition and the standard of living. So arguably, you can say that the only logic of prohibition has to be if you can bring it under the question of the level of raising the level of nutrition and the standard of living of its people. Of course, that's point one. And second is, of course, the consumption, except for prohibition of the consumption, except for medical purposes, of intoxicating drinks and drugs, which are injurious to health. The intoxicating drinks and drugs are not prohibited in and of themselves. They're only prohibited when you can show or demonstrate that they're injurious to health. Right? So this is what his point is. It's a kind of a accommodation of an ideological dissenter using the logic of containment of the demand within the frame of nutrition and the standard of living. And that's the argument which he puts with respect to 47. Let's look at 48 now, which is the entire question of slaughter. Yeah. Read 48, please.
Organization of agriculture and animal husbandry. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and drought cattle.
Yeah, again, if you go back to the Constituent Assembly debates, this is a very heated topic. It's a very heated topic because again, within the imagination of the Hindutva groups or the Hindu right groups, how prohibition of cow slaughter is an essential dimension as far as the way they see the Hindu religion itself. And obviously, as far as Nehru and Ambedkar are concerned, if you put in the question of cow slaughter as a Hindu as a Hindu as a Hindu belief, it will go counter to what both of them believe in. Right. So the strategy they seem to come up with again is you try and contain this entire question of cow slaughter within the broader framing of organizing agriculture and animal husbandry on modern and scientific lines. Right? That's the one. That's again the question of trying to contain it. But the other important point which Karna makes is the question of containment and also the question of what he calls it's both. It's both a form of containing a key ideological demand, also deferring a key ideological demand, right? And so it's both, and that's a very important dimension because though I mean, arguably, right, the both Nehru and Ambedkar succeeded in maybe defanging the demands of the Hindu right at that moment in time by saying that we don't place the cow in any kind of a broad kind of framework of Hinduism or of the Hindu religion. We place it within the context of science and agriculture and animal husbandry, right? They do that, and possibly it's successful in an earlier period of time. But over a period of time, in terms of judicial interpretation, right, it's expanded the meaning of the what is the cows or what are the cattle which can be slaughtered, right? And today we have a range of cow slaughter laws, which might actually make this look quite innocuous. Article 48 look quite innocuous because the range of ways in which the slaughter, not just the slaughter of cows. If you look at the Maharashtra law, it's about even the possession of beef, which stood prohibited. Of course, got struck down, but the law at the time is criminalized even the possession of beef. Right. So there's a ways in which, for example, the this particular provision uh, is actually today the Hindu right can rightly argue as deferred. All that happened is that the demand at that moment of the prohibition of cow slaughter deferred. So very rightly they can argue that at that time our forces were not very strong. The most we could get was this, but it's fine. We worked with this and we used this to ensure that today there's a new kind of a constitutional settlement. There's a new way in which this entire provision is understood. And I think similarly, the UCC question, right? UCC question is deferred. It's a question of constitutional deferral to future point in time, but the future point in time is today. So today we face all these issues, in a sense like chickens coming home to roost, where you say that the issues which are deferred at the moment in time, they become very central and key, and they have been reopened today, as it were. Right? So this question of deferral and the question of containment and the tension between both, and how what was deferred, what was contained at that time, is today now become open, as it were. Right. So that will broadly put, that's the way we can think about the cow slaughter question, the prohibition question, as well as the UCC question. We'll look at one, the other one I want to look at, and this I think is also an important one, and we'll end with that as far as I can see, is the wait, maybe I'll just open the Tarnav article once. We'll look over some parts of it, since we haven't opened it at all. Apart from looking at the title, I think that's great. Yeah, I encourage you to read the article on your own, but maybe just quickly we look at some parts of it, what I was mentioning. Okay. Yeah, this might be a little too, I think, technical. Leave this aside for now. this is the core point I want to make. The two consent-seeking strategies that can be seen in the relevant type of Indian directives are containment and constitutional incrementalism. Right? I think this is the point, which is that cow slaughter, you think of it as containment. Cow slaughter, you also think of it as constitutional incrementalism. You look at it either ways, right? And arguably, a very successful strategy in the last till maybe the current era, where you had the success of the Indian Constitution, because you've been able to accommodate the ideological dissenters, right? If you say, I mean, there's some people, of course, will argue that why is cow slaughter there at all, or why is prohibition there at all? And the answer to that is the Constitution is, end of the day, a product of a compromise. And you can only be sharp or brilliant in how you arrive at your compromise. And arguably, the framers were very, especially the both Nehru and Ambedkar, were very brilliant in terms of ensuring that you accommodated them without conceding to their dissenters a greater space in the framework of the Constitution. That's one way to think about it. But from the point of view of the dissenters, their entire point is our time will come. But either way, right? Both are right. The dissenters were right that the time will come, and the framers were right that no, we've contained you, right? And this is what allowed for the longevity of the Indian Constitution. The fact that both had a stake in the continuance of this regime. One grouping because they felt that the ideas are fully there in the Constitution. The other grouping because they felt that it's not fully there, but at some point we'll get it. So we are okay. We can do with this now, which links up, of course, to the new constitutions which are now being drafted, which I gathered, which was shared on the group, right? Which is going to be unveiled in the Kumbh, which is a Hindutva constitution, which will remove cow slaughter and remove, I think, the UCC from its DPSP non-enforceable part and get it into a more fundamental or more enforceable part, as it were. Okay, I don't think I want to say more about this. Wait, one more point on this. Okay, we'll look at that. Okay, I'll get to the. Right. See, the one point I made earlier is, okay, the directive principles of state policy. One way of thinking of it is part of the directive principles of state policy are really about the entire issue of social and economic rights, right? It could be, for example, the right to work, the right to education, just and humane conditions of work, maternity relief, living wage, etc. All of that are really about the social and economic rights. One part of it is, of course, the entire question of what we refer to as the accommodation of ideological dissenters, which is the prohibition, the cow slaughter, and the UCC. That's the second part of it. And the third part of it is what you look at as, in particular, 39 B and C. That state shall in particular direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good, that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. Right? And if you look at these two, 39 B and C, how are they different from the entire question of social and economic rights? You ask that question, you'll say that these are broader in the imagination and the thinking than the question of social and economic rights. Right? They are about the fundamental structure of the state itself. That is, how is the state to be structured? How is wealth in a society to be structured? How is the economic system to operate? How do you ensure there's no concentration of wealth to the common detriment? These are questions which are, I think, right, related to the question of policy and little beyond the question of rights, social and economic rights, which is a slightly narrower frame, as it were. So it includes this dimension as well. And this, of course, is in Tarunam's argument, is the accommodation of the ideological dissenters, who could be in this case the communists or the socialists, because you're talking about a fundamental way society, the state is to be structured, and that again you accommodate it in the directive principles. This, of course, can also, you can link it back. You can link it back to our discussion on the on 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 the on Ambedkar's closing speech, right? The I think we talked about it. He says on 26 Jan 1950, we're going to enter into a life of contradictions. In social and in political life, we'll have equality. In social and economic life, we'll have inequality. And the point he concludes with is, he says that as long as this inequality exists, there's a danger of the structure blowing itself up. Right? So the life of contradiction is not a life of stability. There's always a danger of of you getting overwhelmed, or the state getting overwhelmed by the nature of the contradiction itself. So the point being that this is a very, I think it's a very critical point. This entire question of 39 BNC, and it's a tragedy. The Supreme Court has not thought of it as critical as we're making it out to be. Maybe one quick point on this is, if you look at 39B, right? There's a recent judgment of the Indian Supreme Court. I think it's 9 judges in the Supreme Court, which the majority holds that what do you mean by material resources of the community? Does material resources of the community include private resources? Does it include private property? The majority holds that the material resources of the community does not include private property. So the understanding is that the state cannot cite 39B as a justification for taking over private property. You can't say I'm taking over private property because I'm ensuring that the 39B is fulfilled, that the ownership and control of the material resources are so distributed as best to subserve the common good. That's one point. But there's also very important, I think in this case, a very important minority judgment by Justice Tulia, which makes the opposite argument. Opposite argument in the sense that saying that material resources should include private resources, private property as well. Because you have to, because if you don't do that, then how do you fulfill your objective under 39B? How do you fulfill that? And if you don't fulfill, if you want to fulfill 39C, right, that the ownership of the economic system does not result in the concentration of wealth, B is very vital. Unless you can use private resources, unless you can distribute private property in a way as best to subserve the common good, how do you ensure 39C? And if you can't do this, if you can't distribute private resources in this particular way, going back to the preamble, how do you ensure justice, social, economic, and political? And how do you ensure what Ambedkar is telling us? How do you ensure that that we resolve this contradictions, the life of contradiction, right? How do you ensure that economic inequality doesn't continue? And how do you ensure that the structure doesn't blow itself up, right? So all of these questions have been given the go by in the recent judgment by the Supreme Court. I think we have a bit of the judgment, which I'm not going to take you judgment, but I'll take you through a piece which we wrote on the judgment, which is slightly easier to look through now. Yeah. It's the PUCL, I think, last time's bulletin editorial. I'll just share it with you. Is the bullet? Can you see the bulletin text?
Yes, Arvind. It's
Oh,
visible.
wonderful. I just want to take you to Justice Dulia's opinion. Yeah. Just read this paragraph onwards. Yeah, somebody please read.
However, the minority opinion by Justice Dulia was cognizant of the inequality in income and wealth and the growing gap between the rich and the poor, and held that privately owned resources should be seen as a part of the material resources of the community, as it is only then that the purpose of Articles 38 and 39 is fully realized. Justice Dulia's opinion finds its constitutional voice in Dr. Ambedkar's speech in the Constitutional Assembly, when he precisely said that on the 26th of January 1950, we are going to enter into a life of contradictions in politics. We will have equality, and in social and economic life, we will have inequality. We must remove this contradiction at the earliest possible moment, or else those who suffer from inequality will blow up the structure of political democracy, which this assembly has so laboriously built up.
Excellent. Okay. So I've already mentioned this, so I don't think I need to further elaborate on this. But I think the question of what is the evidence for the inequality and what are the consequences of the inequality, we also need to engage a little bit with. I mentioned this before, but I think we'll share the piece now, which is the again it's a book by by Piketty called Capital and Ideology, and a recent piece by him, actually, a piece on India, looking at India and the question of inequality as well as wealth and income. Right? And the argument, not the argument, the evidence, Piketty, who's again an economist, was a very well-known economist today. The evidence which Piketty presents is that India is today among the most unequal societies in the world. Right? I think the figure, I will look at it now, but the figure is 1% of the population earns around 22% of the income. 1%, 22% income. And the bottom 50% has the very negligible share of the income, as it were. That's the figure he presents. And the argument he's making is that the billionaire Raj, which he calls today, is as bad, if not worse. Actually, it's worse than times during the colonial period. That is, India is a more unequal society today than it was during the colonial period. Of course, the two questions, of course, what are the consequences of this kind of inequality? That's the Ambedkar's argument in the life of contradiction that will blow itself up. That's one argument. The second, of course, is if it's going to blow itself up, what then are you going to do about this? What then are you going to do about this? Brings up, of course, to the question of the what are the policy interventions which one can think of to address these questions of inequality or rising inequality. Yeah? So I'm going to just take you through the judgment, also not judgment, sorry, the article briefly. Yeah, wonderful. Yeah, this is the piece. So please read it more at your leisure. I don't think we put it on the reading. I think we did.
We did, Arvind. We did.
We did. Super. Okay. Yeah. This is the figure, of course. 2014 and 2015, 2022, 23. Whereas the top end inequality has been particularly pronounced in terms of wealth concentration. By 2022 to 23, the top 1%, again, think of the figure 1%, income and wealth shares. Income is 22.6%, right? 1% have 22.6% of income, and 1% have 40% of the wealth of this country, right? It's at the highest historical levels, and India's top 1% income share is among the very highest in the world. In line with earlier work, we find suggestive evidence that the Indian income tax system might be regressive when viewed from the point of view of net wealth. But I want to take you through some more parts of this piece. Yeah, this is the same point. But yeah, I think this is useful. Just somebody just please read the highlighted part. Yeah, somebody please read.
Yeah.
The top 1% wealth share stood at 40.1% in 2022 to 23, also at its highest level since 1961, when our wealth series begins. In other words, the billionaire Raj, headed by India's modern bourgeoisie, is now more unequal than the British Raj, headed by the colonialist forces. It is unclear how long such inequality levels can sustain without major social and political upheaval. Whether there is no reason to believe income and wealth inequality will slow down by itself, historical evidence suggests that it can be kept in check via policy. Implementing a super tax on Indian billionaires and multimillionaires, along with restructuring the tax schedule to include both income and wealth so as to finance major investments in education, health, and other public infrastructure could be effective measures in this regard.
This is a very, I think, a very significant paper which should be more widely known. So I urge all of you to read it more closely for the evidence that it's presenting. But the argument, right? The argument, of course, the evidence is the question of high levels of inequality, which is obvious from just this one figure which you have over here, right? 1% has 40% of the wealth and 23% of the income. And the other point is making in almost a low-key fashion. It is unclear how long such inequality levels can sustain the major social and political upheaval. Again, Piketty's other work, right? If you go to his Capital and Ideology, the point he's making is in his own work, it's not that unclear. The point he's making is the world was the most unequal just in the period after the French Revolution, where the levels of inequality were as high, right? Were very, very high. And his point is that high levels of inequality were obviously unsustainable and that split the world into both World War One and, of course, then World War Two. Right? So the entire question of social and economic instability really flows from levels of inequality. And levels of inequality are something rights alone can't deal with. You need something like the director principle, certain B and C, to point your direction, to point your eyes in the direction of what this concentration of inequality, or why this concentration of inequality really needs to be addressed. Right? That's one kind of a point about why really everything is at stake. Right? In the Piketty's argument, your entire constitutional edifice is at stake if you don't fundamentally address this question of economic inequality. That is central and key to any rights imagination that you may have. That's the point he's making. But the second very important point he's making is, okay, that is great, but what is the way you can redress this question of inequality? And the argument he's putting forward is that here we have to think more broadly on the question of rights, right? And the argument here is you have to think of taxation on wealth and income. Traditionally, human rights lawyers or human rights people don't think of taxation law. That's not a primary idea which comes to one's mind. But his argument is you can't address this through policy measures which ignore the question of taxation. So the challenging question he's raising is you need to be up to date, or people in this I think in this grouping who are not lawyers and who come from different backgrounds There's a very, very important role people have to play. As far as economists are concerned, tax experts are concerned, chartered accountants are concerned, etc. Right? Because what you need to think is how can you think of a tax regime which can get into a sense of revenue as far as the state is concerned and allow the revenue to go to education, health, and other public uh, infrastructure. That's the broad kind of an argument which he's making as far as this piece is concerned. I don't think I'm going to go into any further detail on the piece because this summarizes, I think, to my mind at least, quite quite powerfully what the argument is making. Of course, a range of things, right? Because range of things, which is the entire question that the point he makes later is tax is so far for the question of income, but tax on the question of wealth is very, very important, and that's been left out, right? The question of wealth tax is very, very important. The question of, again, his policy proposal, at least in his book, is saying that what we need to ensure is that every person has an equal start, right? When you say equality of opportunity, every person on graduation must have an equal start, which means every person on graduation or is given a certain amount of money, right? Every person, right? And how do you finance that? By taxation on wealth and wealth in particular. Right? So it's a range of where I think it's a very, very important piece to discuss. And though it's up online and it's free, I don't think we've seen enough discussion on this particular topic as a critical intervention in the debate of 39 BNC. And of course, it's a big tragedy that the Supreme Court, when they had the opportunity to address this frontally, right, looking at all of this evidence, choose to ignore it. Who does? I think the last point I'll make is that when we were reading we were looking at the analysis of the various manifestos during the last election, we found that the Congress manifesto interestingly cited the Piketty piece to make the argument on why inequality is a core issue which needs to be addressed. So there's a certain kind of a political purchase on this question, but I think we really need to build on that to bring this also within the debate on human rights. How does not just social and economic rights, how does inequality, how does the question of inequality become a part of the discourse on human rights? Is the larger question being raised here. And the answer is it becomes a part of the discourse through the entire question of the directive principles of state policy. Getting back to why the directive principles are absolutely central and integral to addressing this question of what Ambedkar calls the life of contradiction. Okay, I'm going to end with that and leave it to any comments Saila has, and we'll take it forward. We'll end with that.
Michael has raised his hand. We wait for his question, or Saila, do you want to come in?
Yeah, no, just to kind of wind up, because in the last 10 minutes, just to add to what Arvind has given all of us overall the perspective in terms of the directive principles and how the directive principles have been used practically in legislations or in interpretations. I just wanted to give you a brief idea, because if you look at all our labor welfare legislations, whether it is the Minimum Wages Act or whether the maternity benefit or, all the other industrial laws with regard to the Provident Fund, pension, all these labor welfare legislations actually take inspiration or actually are towards fulfilling the goals set by the directive principles of state policy. So, and in fact, most of the legislations in their statement of objectives say so in so many words. And the courts, when the constitutional validity of many of these enactments were challenged, for instance, the Minimum Wages Act was challenged by the industrialists by saying that you are, interfering in our right to conduct business. And in fact, in one of the earliest challenges, the trade unions, the workers themselves came forward and said, no, we don't want minimum wages. We are willing to accept whatever wages the employer gives us, because that is a kind of, oppression that they are in, that they do the bidding of the management. And even in such situations, the Supreme Court said, no, it's not for these individuals to say yes or no, that they are willing to be exploited. So because you will have to read the fundamental rights, the right against exploitation, your right to live with human dignity. No person who is exploited can live with human dignity. So you read your 2120 and you also then read your directive principles of state policy. Now all this reading comprehensively will give you the purpose of the legislation, and the Supreme Court has actually used this interpretation to uphold the constitutional validity of all these enactments and to reject any challenge to it. Similarly, the nationalization cases, whether it is the bank nationalization or whether it is the transport, the bus nationalization, many of these things, the Supreme Court again took inspiration from the directive principles of state policy. So very proactively, for instance, even 39, in 39, there is one, I think 39D, talks about equal pay for equal work. And in one of the earliest judgments, I think Justice Chinnappa Reddy, I think in Randhir Singh case in 1983, where Chinnappa Reddy, that was a case of a driver, a permanent driver versus a temporary driver, and a temporary driver comes to court saying that I should be paid the same wages as the permanent driver. And the Supreme Court actually takes inspiration from Article 39D and says, the directive principles of state policy mandate that there should be equal pay for equal work between men and women. So he says, if there should be equal pay for equal work between men and women, then it should equally be so between man and man. So between two drivers who are discharging the same level of work, you should be paid same wages. Of course, subsequently, that principle of equal pay for equal work has been so watered down today that it almost becomes ineffective. But again, just to drive home the point that time and again the Supreme Court has relied upon the directive principles of state policy to support state action. Again, the executive actions in terms of giving benefits in backward areas. If you set up an industry, you're getting tax concessions. You could take inspiration from Article 38 in terms of distribution of wealth and promoting, so your many of the executive actions, if you look at it from the perspective of the directive principles, you may probably find a logic. And in any instance where you find that a state action is actually going against the directive principles of state policy, then probably, I mean, we are yet to test it, but I don't know if a constitutional challenge will be maintained if we are able to show that a particular state action is against maybe not part 3 but part 4 of the Constitution. So just to give you a roundup on how it has been used in courts. Yeah, so now we can open up for questions. I think we just have about 5 to 7 minutes.
Yeah, Michael.
Yeah, I was very interested in these last 10 minutes or so of discussion about economy and Piketty or Piketty, because I've put in the chat that he's been very closely associated with a movement, a global movement that happened during the pandemic of this group of female scholars, which became a global movement for democratizing work. And I've also put in the chat a link to a lecture that or a talk that Piketty gives in India. I don't know where it is exactly, but there's a panel, and he gives he gives a map, a world map, showing the degree of inequality in different parts of the world and so on. And India comes pretty high up, but I'm only making this point because of this global movement, which seemed to me to be a really inspirational group. They produced a manifesto and a book called Democratizing Work. And as I say, Thomas Piketty has been very closely associated with that. And so has John Dres, who lives in Jharkhand and has written a book with Amartya Sen. And so I thought I'd just flag all that up because it's something I know something about. And in fact, I met the person who really instigated this global movement, Isabel Ferreiras, who's a professor of sociology at the University of Louvain, and she's been very, very active in creating this global movement for democratizing work. So I thought I felt duty bound to mention it.
Thank you. Thanks, Michael. Thank you. I was not aware of it, so we'll look up this democratizing what do you call it? The democratizing work movement, right?
Yeah.
Thank you for that. Jonathan, yeah, anything more?
Any questions, any thoughts, any confusion, anything you'd like more clarity on? Still a couple of minutes. Okay, then I only have a couple of questions which I'll ask. So I think I've heard many sort of people who are very passionate about social justice from a Marxist sense sort of say that no, but the property rights coming dictator principles, they did not intend to do it, but eventually it happened, which is why we got sort of screwed. And now what about universal education and health? But eventually factors of production, if we don't get, then haven't we lost the entire battle towards equality and social democracy and whatever? So the argument is basically also hinting at against the intention of the constitution makers. So in an argument like this, what would be the logical, rational sort of a response? Not taking sides, obviously, but what would be the response to this?
I think you'll go back and say, read the Constitution, and the question of the preamble and the preamble commitment to social economic justice, the Director Principles 39 PNC, and look at how all these provisions interact, and go back to Tarnab's argument of a constitutional deferral. Sure, the idea of what you call what I understood you saying is that the right to property was there in the beginning. That's part of the problem, right? But the right to property is now not there as part of the fundamental rights. It's there as not there as a constitutional right. It's not there as a part of the fundamental rights chapter, as it were. All that being said, I mean the fact, right? I mean, is the Constitution fundamentally a bourgeois document? If that's where you're going towards, I think it is, right? And but it has within itself again the possibility of what you call the constitutional deferral point. That is there a possibility? The point is this, right? It can go. It is going, right? Obviously, in the direction of of what the Hindu right wants in terms of the UCC, etc. But can it go in the direction or the socialists wanted, which is 39 BNC, right? That possibility is there because the language is there. How does the language become more central in terms of a constitutional imagination? How does that idea of a C3 or a constitutional vision become more central to your imagination of the Constitution? And I think, of course, the recent 9-judge bench judgment was an opportunity which was passed by, other than, of course, the Dulia dissent.
And of course, again, going back to the context in which we passed the constitution, no? The strife, the partition, the short duration. So I think they were, and the various forces. So they were making the best of, I think, the situation also. So, I mean, it's very easy for us to sit back and critique and, sit in judgment about the intention. But I think we have to be a little more realistic about also the historical context in which it was, because there were very, very many revolutionary, I mean, universal adult suffrage, and I think these were far ahead of those days. So I think we'll have to look at it more positively.
Satya has a question. Article 37 says the provisions contained in Part 4 shall not be enforceable in Indian court. Could you please elaborate on this? No, Article 37.
No, we read it. As I said, Saila, would you like to please go ahead?
I mean, for instance, if you take any of these fundamental rights, it is like saying that, okay, there shall be an uniform civil code. Now you can't go to court and say, okay, tomorrow you please bring in a uniform civil code. They cannot be a direction by the court to say that you ban cow slaughter or you bring in prohibition. There have been many writ petitions filed saying that you introduce total prohibition. So when you say it is not enforceable, it means that you can't go to court telling them, and the courts cannot direct the state to do it. For instance, ensure that everybody is, given right work. I mean, Article 21, right to livelihood is also there. But it's not practical that, the state can provide employment to everyone. So these are the constraints in which that is also, I think, comes in Tarnab's argument that, they were also looking at the fact that many of the ideals and the goals of the directive principles were also not practical at that juncture, historical juncture, where we had the wherewithal, the wealth, the infrastructure to provide the kind of facilities that are, conceived of in the directive principles. So it's precisely that. You cannot go to court and say, please give a direction asking the state government or the central government to do A, B, C, D to implement or enforce the directive principles of state policy. But the other part of it is, if there is a law which is, going towards fulfilling any of these objectives, and if there is a challenge to it, the fact that the law is towards fulfilling the directive principles of state policy is a point to uphold the constitutional validity of that act. So that's what the nationalization was all about, where private property was taken over, but that was upheld because it is in furtherance of the directive principles of state policy. But there cannot be a direction. You can't go to court and tell the court, you please tell all the government that they should nationalize all the banks. That cannot be done. So I hope you get the difference.
Then can the UCC of Uttarakhand be questioned in court? Is a question.
Of course, it can be questioned because while yes, it is in furtherance of the directive principles of state policy, we will have to see whether in trying to, in the garb of, fulfilling the directive principles of state policy, whether it is actually violating any of our fundamental rights. If it does, then the fundamental rights portion will, see, any act, it can be upheld in portions. It doesn't mean that the entire UCC may not be struck down, but portions of it may be struck down. So any law, it's not what the government says it is for us to see whether it's actually, doing what it is meant to do, or is it transgressing, going beyond it. So that's why we challenge many of it as being ultra vires the constitution. So which means it's going beyond the scope. So definitely this registration, compulsory registration of live-in relationships would be a violation of your right to privacy, right to dignity, and we could mount a challenge on that. So merely because it is UCC and it is part of the directive principles of state policy, it doesn't mean that it is beyond all challenge.
But when it comes to fundamental right versus something in directive principles, the former would supersede the latter, right?
I think we can't make these kind of very sweeping, it's all how you calibrate it.
Shankar asks, is the converse also true? Is there a law that is in violation of directive principles? Can it be challenged?
Yeah, that is what I said. We Supreme Court has said, in fact, I think in the Karnataka Road Transport Corporation case, one passing word, they say that today we are upholding this legislation because it is actually giving effect to the directive principles of state policy. But if there is a state policy which is going against it, we may even strike it down, is what they say. But that is still to be tested. Because privatization has been upheld as being valid. See, we have come full circle, no? From nationalization, we have got into disinvestment and privatization. And privatization was also challenged and it was upheld. So I think there's no yes and no answers for all this. It will have to be tested on a case-to-case basis, and the historical context, everything makes a difference as to how we can advance a case.
I have a question. When Arvind explains about right to privacy, he says that's about the right to choice also. So when it comes to religious conversion, that is again a right to choice. In the Constitutional Assembly debate, when Nehru said that propagate is inherently having the right to convert also. Ambedkar says that when one can convert for material benefits also. But now we have in 18 states that right to freedom of religion, in the name of Act Right to Freedom of Religion, it prohibits the right, the conversion for material benefits. So how how it is overruling the right to privacy? I want to understand that.
Yeah, that's a good question. The quick answer to that is the Supreme Court judgment in the 1970s, delivered in an emergency, which actually upholds the then Orissa law, which prohibits conversion, and it holds that the right to propagate does not include the right to convert, which seems almost making nonsense of the meaning of both convert and propagate. But the 75 law was delivered before Kutuswamy, which is 2015. So now you have a basis to challenge precisely, right, the provision which you're referring to on the basis of the right to privacy. That you have that you can challenge on the basis of this law. There have been a range of challenges which have been filed already, but we don't have it's not come up in that sense for hearing or decision as yet. Okay, I think we can wind up then. I think we're past our time.
Yeah, 10. Past 10. Yeah. Okay. Good night.
Okay. Good night, everybody.
Thank you, everybody.